The date of dismissal is a vital date if a person is intending bringing a claim for unfair dismissal, because you need 12 months of continuous service to bring such a claim. So the date of dismissal has frequently been a contentious issue before the WRC when employees seek recourse under the Unfair Dismissals Act 1977. This, as I say, requires 12 months continuous service. A recurring question in such cases concerns the role of notice, particularly when it is paid in lieu. Specifically, does the date of dismissal occur on the date notice is given or when the notice period would have expired? This is the vital question. Earlier decisions determined that the date of dismissal corresponded to the expiry of the notice period. In Kinzinger versus Marquito EMEA Limited, a 2016 case, the employment contract contained a clause permitting immediate termination with payment in lieu of notice, disqualifying the employee from further benefits. However, the Employment Appeals Tribunal ruled that such a clause could not override the strict notice requirements of the Acts. It held that the date of dismissal included the contractual notice period, enabling the employee to meet the service requirement to pursue a claim for unfair dismissal. Similarly, in an employee versus a technology company, a 2018 decision, the WRC determined that the notice period was quantifiable for meeting the Act's service requirement, enabling the employee to bring a successful claim. More recent developments then, the Labour Court addressed the issue in a case Action Health Enterprises Limited versus Michael Darcy. The background to this case was the employee commenced employment on the 31st of January 2017 under a contract stipulating, amongst other things, termination with notice. The contract said that the employment may be terminated at any time by either party giving at least 3 months prior written notice or statutory notice if greater. Where notice is given, the partnership has the right to pay you in lieu of notice the amount of your entitlement to basic salary for all or part of the notice period. So, on the 30th of November 2017, the employer dismissed the employee on a no-fault basis, informing him in writing that he would receive payment in lieu of 3 months' notice that the employment ended immediately. Payment was delayed until 17th of December 2017, following intervention by the employee's solicitors. And this intervention by the employee's solicitor was very significant later on. The employee brought an unfair dismissal claim to the WRC, and the WRC awarded €45,000. The employer appealed to the Labour Court, arguing that the employee lacked the requisite 12 months service under the Acts. In other words, they were saying that the employment finished when they issued the notice of termination and paid in lieu of notice. The Labour Court had to determine whether the date of dismissal for the Act's purposes was the 30th of November 2017, the date of the termination letter, or 3 months later, the end of the notice period. This is absolutely critical. The employer argued that the Minimum Notice and Terms of Employment Act 1973 allows parties to agree to payment in lieu of notice, making the date of dismissal the 30th of November 2017. The employer also invoked Section 1B of the Acts, which states that if notice is not given or does not comply with statutory or contractual requirements, the date of dismissal is when notice would have expired. Even under this provision, the dismissal date would be the 7th of December 2017, 1 week's statutory notice. In other words, this would still prevent the employee from bringing a claim for unfair dismissal because he wouldn't have the 12 months continuous service. The employee, on the other hand, argued that the contractual notice provision superseded statutory entitlements, entitling him to 3 months' notice. His solicitor contended that payment in lieu of notice did not negate the statutory definition of date of dismissal under the Acts, which includes the notice period, whether it worked or not. They relied on Desmond Ryan's Redmond on dismissal law, which states that the date of dismissal is deemed to include the notice period for service qualification under the Acts. the Labour Court highlighted two key issues in its determination of the case. One, if the employee was dismissed without notice, Section 1B of the Act applies, setting the dismissal date as the earliest date compliant with statutory or contractual notice. This would have been the 7th of December 2017, still insufficient for the employee to meet the service requirement. 2. The employee's reliance on the contract to claim payment in lieu of notice meant he could not simultaneously reject the contract's terms. The court cited the case Superwood Holdings plc versus Sun Alliance and London Insurance plc, a 1995 case, and Manor Park Home Builders Limited versus AIG Europe Ireland Limited, a 2009 case, to support the principle that a party cannot approbate and reprobate a contract. The court further noted that under Section 7.1 of the 1973 Act, acceptance of payment in lieu of notice extinguishes the right to notice. By seeking and accepting payment in lieu, the employee was deemed to waive notice. Thus, the dismissal date was the 30th of November 2017, leaving the employee short of the requisite service period to bring an unfair dismissal claim. The Labour Court overturned the WRC decision and its award of €45,000, ruling that it lacked jurisdiction to hear the claim because the employee did not have the necessary 12 months continuous service. There are some key takeaways here for both employer and employee. 1. The date of dismissal remains a complex issue in employment law, but this case clarifies that payment in lieu of notice sets the dismissal date as the notice's issuance date if agreed in the contract. 2. Employers should ensure contracts explicitly state that payment in lieu of notice ends employment immediately. Obtaining the employee's signed acknowledgement of this arrangement at dismissal is advisable. And 3. For redundancy purposes and for redundancy terminations, statutory notice rules differ. Under Section 72 of the 1973 Act, the termination date is deemed to be when statutory notice would have expired, even if the employee ceases work earlier. Employers must calculate redundancy payments based on the statutory notice period's expiry. That is the situation, an update on the date of dismissal, the cases or the confusion, the arguments around date of dismissal. I hope it's useful. I hope you find the video useful. If you do, you might give it a thumbs up down below. Thanks a lot.